I could sit here and I can read to you Tony's CV and introduce him with all his accolades. I met Tony, and again I said this last week, about 20 years ago when I was a younger litigator just starting out in civil practice, and I sat across from Tony. I think it was either at a mediation or something to try and get rid of a case. And the interplay, I could tell from there how I told you how to be prepared as your best adversary. He was it. And not that I want to say he's my mentor, but there have been plenty of times I've called him, and I've had the utmost respect for him and his firm. And if you've practiced in New York, you know of his firm. An exceptional attorney. And again, I'm not going to read all his accolades because I want to get up here and have him speak to you. But it's my absolute privilege to have Tony Gair speak to you on depositions.
Thank you, Robert. You look just the same.
Liar.
Good afternoon. It's good to be here. I'm supposed to be talking about taking a meaningful deposition, and you see these topics in the outline, starting with preparation. I'm going to go through them, and probably not in quite the order, but how many of you have had an opportunity to read this fact pattern that was handed out? Some of you have read it? Okay, so because we'll deal with that to some degree. And I'm also going to try and speak not just as a plaintiff's attorney, but from the viewpoint of a defendant's attorney as well, because we have mostly plaintiff's attorneys here. And I've done some defense work, very little, but I've certainly observed enough good and in fact, excellent defense lawyers to know how to do a defendant's deposition as well. Now, what is in an automobile deposition? How many of you have taken a deposition either of a plaintiff or a defendant in an auto case? Anybody? How many of you have taken more than 10 of them? Okay, a few. So let me ask you this. Here we have a case here where we have this four-car accident, if you will. We have Paul Button in his bar with the SUV and the beer in the bag, and his friend Kemp comes and stops on the side of this country road, and then Williams follows him and decides to call up his friend Myers, who gets distracted and picks up his cell phone and drops it and runs into all of them. So you're going to go take a deposition in that case, either as the defense attorney or the attorney for the three injured plaintiffs. What is the first thing that you're going to think about before you take that deposition? What would you think about? Here's what I think about. Why am I taking this deposition? Isn't that the first thing you want to think about? Am I just doing it because it says in the CPLR, oh, now it's time to take depositions? I go and question this particular witness. You have to think to yourself, what is my purpose in taking this deposition? And let's take it first of all as the attorney for the three injured plaintiffs. And I'm taking Bob Myers' deposition, the driver of the car. I don't care about Dennis Walcott. We'll assume that Myers has permission and consent to operate the vehicle. What is my purpose in taking that deposition? Here's my purpose in an automobile case, such as this, where I'm taking a defendant driver's deposition. And it's one purpose and one purpose only. I want to nail that defendant, in this case Myers' story, down. So I have him penned in for trial. I know exactly how I'm going to put in my case at trial. I know if I'm going to have to, and I probably will in this case, because I'm assuming that Button, Kemp, and Williams may have not seen too much. I may need to put on Myers to make out my prima facie case, And it depends on the particular case, but in general, I like to put on a defendant driver on my case. I'm allowed to cross-examine him as an adverse party. So I'm taking this deposition, so when I call Bob Myers at trial, I know exactly what he's going to say. How do I know that? Because if he doesn't say what he told me at the deposition to be the fact, I'm going to be able to impeach him with that deposition at trial. That's why I'm taking it. I'm not taking Bob Myers' deposition to get a lot of documents, and that's another reason you might take a deposition in a particular case. I see an old friend of mine said hello to me, Tom Spear, and years ago, too many years ago, we had this fireman's case a long time ago. And there was multiple defendants. The city of New York, I had it was a tragic case, a very difficult liability case from a plaintiff's viewpoint of a firefighter who was killed in the line of duty. And we had private property owners in the city of New York. And I think we took probably 40 depositions in that case, Tom, something like that. And a lot of those depositions were real, what I would call discovery depositions. I'm looking for documents. Looking for plans, for specifications, for blueprints. So I'm asking a lot of open-ended general questions to get these documents. So there was, for each deposition within that kind of case, there may have been a different purpose. Not in an auto case like this. There's one purpose, and that's and we'll get to how you conduct that and how you do that in a minute. But that's what I would think about, and that's what I suggest you think about. Why am I doing this? Now, preparation. So you're going to be going and taking, in this case, as a plaintiff's attorney, or as a defendant's attorney, you're going to be taking, and all is not lost for if you're representing the defendants in this case, as we'll get to, because Mr. Button here and his friend Mr. Kemp, at least, and Mr. Williams as well, decide to set up this bar on the roadway. And if you read the facts, they're not all the way off the road. That's a violation, and we'll get to that as well, because it gets to preparation of the New York State Vehicle and Traffic Law. So, in order to take that effective deposition, where you're going to nail down the Mr. Myers in this case as a defendant driver, you have to prepare, right? Now, what are you going to do? Are you going to pick up your file at 6 o'clock at night, the night before that deposition, and rummage through it? And even in these auto cases now, when I first started out in auto case, you might have two Redwells. I grew up in this business. I come from a family of lawyers, and when sometimes they didn't even take depositions in a case like this. They'd go try cases. Some lawyers would try 150 cases a year. Unheard of today. 150 cases, and I studied a lot about a lot of these old-time lawyers who practice in our profession. There are some great lawyers. They wouldn't bother with depositions. So, but now, even in an auto case such as this, you might have 4 or 5 Redwells full of we have so much paper now, full of files. So you're not going to sit down at 6, not if you want to do a good job either representing your carrier or your plaintiff who's been injured. You're not going to sit down at 6 o'clock at night before this deposition and then rummage through and pull out the police report. Maybe there'll be an MV-104, whatever you happen to be able to find in a few hours, then look at it for an hour and go, and take your deposition, and because you're going to do a lousy job, no matter how experienced you are. And those of us who've been around a long time, and such as I have been around a long time, sometimes you start thinking you can do that. Don't. I still, to this very day, will go through my deposition file, and I'll talk to you about what that is. And really, there's outlines in this handout that you've been given. There's 3 separate outlines. I submitted one, 2 other people did. They're very similar outlines as to what you would ask generally in an automobile case. I might sometimes, if I really had some extra time, even write out every question and never look at it during the deposition. okay? Just so I got it in my mind where I wanted to go and what answers. And I might have arrows going this way depending upon what the question was and where I wanted to go with it, depending on the complexity of the case. Now, this case we know is not that complicated a case, but it's a case where the technique of nailing certainly Myers down can make your whole case, and you know exactly how you're going to try it based on your deposition, because you're going to keep him roped in by using the deposition for impeachment purposes, and that's what you're going to use a deposition in an auto case such as this for, okay? That's why you want to use it to nail Mr. Myers down, so that you can then use the deposition at trial to impeach him and keep him in line with the story you want to tell the jury at trial. Now, preparation. Preparation for a deposition, when does it start? Well, I think it starts when you first interview the client. It's the same way as a summation. When does preparation for your summation start? I would submit to you it really starts when you first make that decision to take the case and think to yourself, how am I going to sum up in this case? Where am I going with this case? What am I ultimately going to tell the jury? And isn't that going to be based upon what proof you can establish? And doesn't the proof that you're going to establish really start with that deposition? I mean, Nick told you about all the discovery you're going to get and all of that, and you're going to have all of that, obviously. But with that deposition, that's where it starts. So that's where preparation starts. Now, as a general matter, or maybe it's more of a specific matter, this is what the first thing you got to know. And this, of course, as many of you know, is the PJI, the Pattern Jury Instructions, okay? You must know the PJI. I look at the PJI in any case that I get, because what does it tell you? It tells you what the judge is going to say the plaintiff has to prove to make out a prima facie case so that you win. And with regard to motor vehicle accidents and the rules of the road, it starts, the charges do, and this is the most recent supplement, the 2012 supplement, and this starts at charge 2:75, and in the 2012 sup, it's at page 416, and it goes on with all the charges. You got to look at this. You have to know this. You have to know it because you want to intersperse your deposition questions with phrases that are going to be used that are taken right out of the charge. You're expected to see what's there to be seen, correct? And to keep a proper look at, et cetera, et cetera. And you're going to do that throughout the whole trial. And then when the judge charges the jury at the end of the case, the jury's going to say, wait a minute, Gair was talking about that. He must know what he's doing. I mean, but so that's what you want to do. Okay, so the PJI, learn it, know it, look at it, okay? Secondly, in an auto case, the vehicle and traffic law of the state of New York. You want to know what the vehicle and traffic law says about this particular accident. And we'll get to this specific case in a minute, but there are VTL violations on both sides of this case. And the rules of the road are in Title 7 of the Vehicle and Traffic Law, Articles 23 through 30. It's Title 7, Articles 23 through 34. And the definitions, you want to know definitions, and you want to know them. Let's bring it back to this particular case, because Robert very cleverly in his, and I can see he must have written this one, put in this country road. Like maybe it's not a highway, So maybe the VTL provision, which we defendants here want to apply, doesn't apply, but it does apply, and we'll get into that. But so you want to know the definitions. The definitions in the vehicle and traffic law are in Article 1, and they're sections 150 through 159. So it's important to go through those as well. Okay. Now, in a case such as this, if I have a case where I'm representing as a plaintiff, let's say, a passenger in a two-car accident, and the plaintiff's asleep at the time of the accident, and the real argument's going to be between the two drivers involved. Plaintiff doesn't know anything about liability as to what happened, isn't going to give any useful testimony. I don't care if the plaintiff's deposed 2 months before the defendants, or a month, but whenever. But in a case such as this case, or a driver against driver case, or a pedestrian knockdown case, where my plaintiff pedestrian is going to know facts about the accident and a liability, I want the deposition of the defendant and the plaintiff to be on the same day. And I'm not going to produce the plaintiff in a case like that, and I'm going to put it down in the PC order. Years ago, we didn't have these PC orders, but we've had them for a long time now. But you're going to put it down in there. You want them the same day. Why should I, as a plaintiff, who have someone who have a client who knows about the liability, is going to testify about his observations at the time of the accident, why should I produce him a month before the defendant comes in and has time to testify accordingly? Okay? I mean, maybe I'm a cynic, but we all know I'm not talking about perjurious testimony. No one here does that, I would hope, and don't ever do it. It's not worth it in any case. But testimony can be adapted so in a light more favorable, certainly if you have time to digest it like that. So you want the depositions on the same day. Now, what I think is a very good idea in these cases, you're getting all this discovery in, as Nick talked about, and make up which I call it an EBT file, just like I have a summation file, because as I'm working on the case, maybe I'll say, hey, this would be a great line in the summation or in the opening, and I'll write out a note and throw it in that file. So have your deposition file so you don't, because we're pressed in our business. You know how busy it can get. So you might not be able to start really working on a case like this till a day before the deposition. So if during the course of your preparation of the case, if you've prepared your deposition file with your police reports, your photos, your medicals, anything to do that you're going to need to properly take that deposition, and you already have it in your deposition file, and you know you've put it there, or you've had your assistant put it there, or your secretary, and a good secretary makes you or breaks you in this business. I've had very few secretaries in my career. They usually stick around with me. I don't know if that's because I'm a nice guy or I pay them a lot. Probably because I pay them a lot. But so you have that file, you whip it out. You don't have to go through all of that. And you can sit down and do your outline. Now the outlines, it's interesting. I have the outline that I drew up years ago and have added to in this course book, and then two other people put theirs in, and I said they're very similar. They don't have every question written out, but they have the topics that you go over. I would suggest to you that if you're first starting out taking depositions, you really write out the questions. So it gives you an idea how you want to ask them, how you want to phrase them. And as you get more experience, you can jot it down, and you can do less and less because you know exactly how you want to ask your questions and where you want to go. Now, so what do you need? Let's be specific. for preparation. Let's talk about this case. You need scene photos. Okay? You're going to have, you know, in this day and age of cell phones, a lot of times now people will take cell phone photographs of the accident itself, so you can get really good photos of of damage to the vehicles at the scene, location of the vehicles, after impact, etc. You get those, that's great. Still, you want to send out, if it's a big enough case, you want to send out a forensic photographer to really get good shots that you can use 8x10s at the deposition, which you'll later use at trial. If it's not a huge case and you're going to have an investigator, you can have your investigator take pictures. Good investigators know how to take these pictures as well. You'll have vehicle photos. You'll have your police report. You'll get any party statements. You'll ask for those, and you'll have the medical records. And those are the basic documents you'll have in this case. Now, conduct of the deposition. And I find that what's in these auto cases, when I'm taking a defendant driver, and here I'll be taking Mr. Myers' deposition, pacing is very important. What do I mean by pacing? I mean, don't sit there and go, so, Mr. Myers, did you have a cell phone with you on June 6th of 2012? Yes. What kind was it? Who cares what kind it was? But move it along. You have your outline, but listen to the answers. And you don't have to be wedded to your outline. You may get a great answer. I still remember this case that Tom and I were involved with, and I forget who the witness was, and I was through with my questioning, and Tom was questioning. I still remember it. I have the deposition. I don't remember anything about it except that Tom asked this one question, and this witness, who was being really difficult with me, blurted something out. And I don't think Tom was too interested in that. He wasn't even a target in it, as I recall, but it really helped me, and I was listening. So then I got to go again, and I think I spent 20 pages going after this guy on what he had blurted out to Tom, which if I had decided to pick up my New York Post and said, who cares what Tom asked him, I'm done, I would have never heard that. So listen, because you're going to pick things up, and you can always put a little check mark by your outline where you were, and after you've exhausted your questioning on this great answer you've gotten, which you may not want to exhaust too much, you may get what you want and you want to leave it there and not have him come back and change it, then you can go back to your outline. So I'm questioning Mr. Myers here. So, Mr. Myers, on June 6th of 2012, you were operating a motor vehicle, were you? Yes. And you owned that motor vehicle, did you? Yes. And you had operated that motor vehicle for quite some number of years, had you? Yes. And at the time of this accident, you had a cell phone with you, did you? Yes. And you got a call on that cell phone, didn't you? I did. And you answered that call, did you not? Yes, I did. And in fact, during that call, objection! You're leading the witness. What? You've gotten that, haven't you? Tell me who's gotten that. You're leading the witness. Of course I'm leading the witness. What am I here for? I'm here to cross-examine this witness. He's a hostile party, and pursuant to CPLR 3113C, I am entitled to cross-examine the witness just as I would be at trial. Now, you used to get this all the time. Before they changed, they adopted the uniform rules for the conduct of deposition, so now we pretty much have the federal rules where no one is allowed to obstruct depositions anymore. And it doesn't go on that much anymore. In the old days, years and years ago, especially in the medical malpractice and the products liability cases, you'd have cases where the opposing attorney would say, objection, don't answer the question. What do you mean don't answer? I don't want to answer the question. Why? I just don't want him to answer. Well, tell me your reason. Form. I'll risk the form. No, you can't. What do you mean I can't? So I'd have or it calls for an opinion. No kidding. Yeah, it does, you're right. And it was very frustrating. So we had form motions with all the cases that we gathered over the years. Rulings motions, we used to call them. And every time we got that done to us by a defendant, the next day, or the 2 or 3 days when we got the transcript back, and I'd order it expedited where I had an obstructed deposition like that, we'd make our rulings motion, and we'd go to court, we'd win, and we'd bring that witness back. And after a while, the firms got to know you, they know you'd make this motion, and you wouldn't have your deposition obstructed. Now, truth be told, you shouldn't obstruct a deposition. I could probably sit through a deposition with Robert Glick when if he was deposing a plaintiff I represented, and never say a word, because he's going to be asking questions that are relevant, that are germane, and I don't have the right to direct a witness not to answer anyway. Pursuant to the uniform rules, the only, and it's always been like this, even before the uniform rules, and when we had the stipulations, which should be, by the way, in the transcript. I put a copy of an auto deposition in this handout, and you'll see the whole uniform rules are set forth as the usual steps. I used to go in as a young attorney and say, what are these usual steps? But these are the stipulations that we know about. But the only objection you have to make is to form, or you waive it. That doesn't mean you can direct the witness not to answer the question based on form, because it clearly says under 221.1a under the uniform rules that you have to answer the question. And it refers to those questions. The waiver as to form is in 3115 of the CPLR. So you make your objections to form, not objection form, fine, shut up, answer the question. Or if you want to be really careful as the examining attorney and you have a question about form and you maybe think that you're not going to be able to get the witness in a trial, or you really think it's an important question and you think you were improper in the form, you can always rephrase it, okay? There's no more of these speaking objections or objection. Is what you're asking him as to whether he actually dropped the cell phone or it fell? I mean, no, dude, shut up, you know? Leave me alone, you know, stop. I get less tolerant for this nonsense. And don't tolerate it. But at the same point, be respectful, okay? Oh, respect your adversary. We live in a very small community of lawyers. The personal injury bar, the medical malpractice bar, the products liability bar. We're a very small community. We know each other, and word gets out. And you don't want to be known as a jerk and someone who is arrogant and treats people discourteously. You want to know as a gentleman or gentlewoman, a decent person who if you're not going to be screwed with, you're not going to screw with the other person. Isn't that the type of reputation you want? That's the kind of reputation I want. That doesn't mean that you let people walk over you, okay? If people are going to start acting like that with you, you can act that way accordingly. But never act like that for no reason. Don't ever get it personal. We're in a business together. Both sides are doing their jobs. Don't ever make it personal. Most of the people I hang out with who are lawyers are defense lawyers, because that's who I deal with all the time. I see these plaintiffs lawyers at these dinners we go to where they're all telling me how they never lost a case and the last $10 million verdict they got. I think that Max Stoyer, who is a great trial lawyer. He tried the Triangle Shirtwaist Fire case back in, I think, 1919, said the only lawyer who never lost a case is the one who never tried one, okay? And that's the only lawyer, despite the many plaintiffs' lawyers you may run into at these Bar Association events who have never lost a case. Okay, so let's get specific. I have plenty of time.
No, actually, no. No, talk to me about 12 minutes. I'm sorry.
Okay, I got plenty of time because I talk very fast. This is how you take the deposition, the pacing. Boom, 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 boom. Got you. Right? Okay, now, specific violations. Now, how many of you here are defendants, lawyers, particularly? Okay, so are you dead in this case? Because your guy, Mr. Myers, not only violates the vehicle and traffic law, cell phones, 1225C, don't answer them. Don't talk on the phone. It's a violation. And here, we have more than that. He drops the phone. So you're dead? Are you giving up? No, of course you're not. All right, so what? He answered the phone, he dropped it, and he went down to pick it up, and he veered off the road, and he hit the moving country bar that's parked in the road, right? What were they doing there in the road? Drinking beer out of a container, this container on the back of the SUV. It's not a bar. It's not like a drive-in, is it? So, what about this? They were stopped, these plaintiffs who now want to sue for these injuries they got because Mr. Myers answered his phone and dropped it and decided to look for it and drove off the road and hit them. They were where they shouldn't have been. And they were there in violation of the vehicle and traffic law. Section, this is why I say you've got to look at this stuff. They were there in violation of section 12021. No person shall stop, stand, or park a vehicle, J, on a state expressway, highway, or state interstate route, highway, blah, blah, blah. Wait a minute. This is a country road. This isn't a highway, is it? Yes, it is. Because under definitions, and I want to move quickly, but it is. You'll see it under, you look at section 118 and 140 of the definitions. This roadway, this country road is a highway, so they're in violation of the VTL too by being where they shouldn't have been. So there's some culpable conduct here that you're going to use when you go to negotiate this case, which you're going to pay money on, whatever it is how much insurance at some point. But you're going to say, you have a defense to this case, at least to get some percentages in, okay? Now, couple of things. How many of you I think we're recording. I can't stand still. How many of you have gone into depositions and heard the deposition start like this? Hello, Mr. Myers. My name is Anthony Gair. I represent the plaintiff, Paul Button. Good to meet you. Good to meet you. I just want to tell you I'll be asking you certain questions today, and if you don't understand any of the questions, please tell me. Do you understand that? I do. Do you understand that if you answer a question and I'll assume that you know that you understand it, blah, 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 blah. The same instructions that you give your own client, now the opposing attorney is giving, right? You've heard that, and I bet a lot of you have done it, haven't you? Who does that when they start a deposition? Raise your hand. Why do you do it? Why? Habit. You read a form once, it looked good? Why do you do it? What's the purpose of it? What are you going to do with it?
Gets you on a roll.
Doesn't get you on a roll. It gives. What about this? Doesn't it give that witness time to get comfortable with you too? Isn't it better to go right after that witness? Were you involved in an accident on June 6th of 2012, Mr. Myers? Yes, I was. You were driving a vehicle at that time, were you not? Yes, I was. You went, blah, you right? Get right to it. Get to pedigree, date of birth, blah, blah, blah. So you have it at the beginning, then get right to the accident. The reason people do that with that preliminary instruction stuff is they saw someone else do it when they were kids. Now, I got out of the habit after my first deposition because I did it like many, many years ago, well over 30 years ago. And I started with, if you don't understand any question, and I'm with this crusty old defense lawyer who must have started in the 30s. He wasn't that old at the time, he was in his late 60s, which is young these days, right? Yes. And he said, do you have a question, kid? I go, what do you, I said, do you have a question? I said, I'm asking, no, you're not. You're giving him instructions. You have a question, ask him a question, otherwise we're leaving. I never did that preliminary stuff again. And then I figured out why people ask those preliminary questions. It's so you think that at the time of trial, when you're going to go and impeach that witness with a deposition, you're going to be able to say to that witness, oh, and I asked you, remember, at the deposition, if you didn't understand a question, I assume that you understood it. You remember I asked you that? Come on. You're never going to impeach a witness with a deposition like that. First of all, it'll dilute your whole impeachment with a deposition, and I've never done it in my life. Have you at trial? No. Have you? No. Here, how you impeach a witness with a deposition at trial? I got 5 minutes.
Yeah.
How you impeach a witness with a party, Myers, or a deposition at trial is, Mr. Myers, isn't it a fact that you were talking on your cell phone immediately prior to this accident? You dropped the cell phone and reached down for it and lost control of your vehicle? Yes or no? No. Mr. Myers, on June 6th of 2012, do you recall testifying at a deposition? Forget recall. On June 6th of 2012, you testified at deposition in this case. Did you not? I did. You were under oath at that time, were you not? I was. And your attorney was there with you, wasn't he? Yeah, he was. And you were given that deposition to review, were you not? Yes. And you made no changes to that deposition, did you? No, I did not. And you were asked at page 2, line 5 of that deposition, blah, 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 blah. Boom. Was that true or not true? It wasn't true. It wasn't true. So what you're saying now is true? Yeah. Well, this was about a year after the accident. Now we're 3 years later. So which is it? When do we know whether you're telling the truth or not, Mr. Myers, if ever? Okay? So the fact is, you don't need those preliminary questions. I want to talk to you very quickly about social media as a defendant's attorney. That's such a hot button issue now. When I say social media, I'm talking about Facebook, Twitter, LinkedIn, all this stuff. As a defendant's attorney, here's my feeling on it, and this is what the courts have been saying, and Roberts brought in a case, because we did this last week, so I was talking about social media, because I was reading this great little article by this defense lawyer. There's all these blogs now, as you know, you can read, and some of them are very good, and he was saying forgetting about social media at a deposition. My feeling as a plaintiff's attorney is I get notices now right off the bat, the first set of defendants' D&I notices, Facebook accounts, passwords, anything posting, off the bat. I don't even, without them knowing whether my client has objection. I'm not going to give you anything. There's no predicate for it. There's no basis for it. There's no proof that A, they had a Facebook account, B, that if they had one, they posted anything, nothing. So at the deposition, as a defendant's lawyer, probe about Facebook, especially with younger people, Facebook, Twitter, etc. Do you have it? And if you can establish a predicate, what I mean by that they did have a Facebook account, they did post, they did delete, they posted about the accident, you're going to get it. And Robert brought in this law journal from yesterday in his decision. Defendants granted disclosure of Facebook postings pre-post dating subject accident. The defendant's attorney apparently, and I didn't read the case, I didn't have a chance, but I just read the outside thing, but it's from yesterday's law journal. The name of the case is D'Agostino. It's in yesterday's Law Journal. They asked, obviously, about it, the defendant's attorney, and they were claiming in this case the plaintiff was psychological injuries and testified about psychological injuries, and then also testified that they had prior psychological problems and, in fact, posted about them on Facebook. Of course you get that.